Good morning, everyone. My name's Adrian Foster. I'm Associate Director with Charles Taylor, working within their UK Complex Liability team. I've been an adjuster for the past 28 years. For the past 25 of those have concentrated on liability claims, principally product and public liability claims, and investigations just tend to involve issues of policy cover and also issues over the extent of the duty of care owed. The team that I work in has 10 people operating throughout the UK, though some people also deal with claims internationally, including home foreign work. As Hayley said, there's some notes and slides available for download, and to a certain extent I'm going to read through the notes and add a few additional comments. I'm going to run through things as follows: brief introduction. I'm going to look at the GDPR regulations. I'm going to make this as brief a summary as I can make. It's not the intention of this talk whatsoever to look at the GDPR in detail or to consider it as an alternative to your own compliance training that you'll receive with your employers. And really all I want to do with the summary is just highlight some of the key issues that we encounter from a claims perspective. I'd then like to look at some new areas or potential areas for new claims, and in particular just to review the consequences of the recent case of Lloyd v Google and ST v L Primary School and the impacts that they may have again on our claims handling. I then want to look at the exceptions to the GDPR applying, and in particular the exceptions that relate to legal proceedings and investigations in connection with legal proceedings. I want to look at the consequences of a DSAR, which is a data subject access request. That is how that might impact on the claims process when a data subject, that's somebody who has data that our insured has retained, makes a request for that data under the Act and regulations. Briefly then I'd like to look at third-party data. This is an area that we're noticing creating some concerns and some issues. That is where the claim itself involves the disclosure of personal private data of a third party. I'm then going to summarise, and I'm then just going to refer to a couple of recent cases, one in relation to GDPR, that's a vicarious liability case, and the other in relation to the court's attitude following COVID-19 and the delays that are occurring to proceedings and portal disclosure timescales and all that sort of thing. When I was young and interested in computers, in 1993 I bought a 430 megabyte hard drive which cost me £260, which was a lot of money. Oh, that's basic schoolboy error. In 1993, £260 was a lot of money for me. 430 megabyte hard drive meant that every pound that I was spending was 2 megabytes of data. This year I bought a 8 terabyte hard drive which cost me £120. So each pound that I spent, it bought me 66,000 megabytes of data. So counting for inflation, I bought 100,000 times the storage as I had in 1993. The internet, similar figures sort of quoted, but generally it is now 4,000 times the speed that it was back in 1995. Data is cheap, the storage of data is cheap, and it is getting cheaper. Every couple of years or so, the price is generally half. So it's easy to see why companies would want to store historical data. Data is also valuable. Many business models revolve around retaining data and then selling it to third parties or using it for their own purposes. The best example is credit reference agencies. We all have our personal information, our credit history held with credit reference agencies who then use that information, sell it on to banks, etc., and that determines the amount of interest that we pay on a loan. It has a financial consequence for us. The General Data Protection Regulations, GDPR, they are a 2016 set of EU-wide regulations. They are EU regulations, which means that they are enforceable within the individual EU countries. It doesn't need to have local jurisdictional legislation to make them enforceable. Having said that, the regulations did include a number of variations which countries could adopt or not adopt, and as a consequence in the UK we did enact them in a very detailed piece of legislation, the Data Protection Act 2018. That followed on from earlier acts in 1984 and 1998 And basically the changes were to account for changes in IT technology, changes in the way we use data, etc. Now, a question that I think is going to be asked of a lot of legislation at the moment is whether it will survive Brexit. There is no indication at all that the government are going to look at data protection post-Brexit, and I can't see any reason why they would have passed an act in 2018, some 2.5 years after the June 2016 referendum. The Data Protection Act contains a number of provisions, and I think we'd all get very bored and require a lot of patience if we review them in detail. And you'll have done your own compliance training, I've no doubt, with your own employer, and you can refer to that if you want to know some of the more detailed elements of it. For the purposes of my talk, I'd like just to refer to Article 9 of the GDPR, which has a similar provision within the Data Protection Act, and special categories of data. This is data that requires special consideration because it is particularly personal to the individual. It can be revealing information about racial or ethnic origin, political opinions, religious beliefs, trade union membership, biometric data, and of interest to us particularly data concerning health. And that is a key point because in terms of our claims and dealing with third-party liability claims, we're often going to be looking for information about somebody's health, their personal history, etc., which would be considered special within the GDPR. Just looking at some of the more general provisions, the Act is split into a number of different sections. There are some data principles which define how data needs to be kept by the controller, the person holding onto that data. And just to concentrate on a few of the words, the data must be kept accurately, only as long as it's required for. It also must be kept securely. The processing of data also requires that it is kept with the person's consent. That could either be via a contract with the data subject. The data is perhaps kept by a requirement of law. So, for example, there is a need to hold on to banking records, etc. It may be required to be kept to protect the subject's interests. An example of that would be child protection. Relevant agencies might hold on to data simply because it's necessary to protect the child. And an important aspect of that is that the consent for keeping data with regard to the special categories, so that includes data regarding health, etc., must be explicit. That is, the person must clearly know at the time they are giving the consent for you to hold on to the data that they're aware of what you're going to use it for. And that consent doesn't necessarily mean consent to hold onto the data. It will also be consent with regard to its use. In other words, they explicitly know what you're going to use that data for. The data subject also, that's the person whose data you're holding on to, has various rights, and these include the right to be informed, the right to access the data, the right to have it rectified, deleted or amended if it happens to be wrong or it's being held for an undue length of period of time, its portability, and a specific provision with regard to profiling. That's the use of algorithms, the use of the data to assess behaviours, etc. I've highlighted in green the word portability there. That's the ability to take the data and move it from one person to another, or from one company to another. And that's a factor that you will notice through. The courts have a tendency now to look at data as a chattel, something we own, something that we have, and something that has value, that we can sell on and transfer from one company to another on the basis that it should give us some sort of reward for allowing people to access it. Data subject access requests. These are referred to as DSARs. This is where the data subject, so the individual whose data is being held, makes an application to the data controller of the company holding onto that information for the data that they have. This is not a matter for insurers as such. It will be a matter for the insured because they're the data controller. So in that respect, we'll touch on this a little later, it's not really for insurers to make decisions about whether data controllers should or should not release data when a DSAR is made. A DSAR is free, okay, unless the request for data is disproportionate. And generally, there's a rule of thumb of £450 of administration time, and that's something that's also referred to in the Freedom of Information Act. The fact that DSARs are free means that they're quite a useful way of getting information about what a company might hold about you, creating a lot of additional work, but also sort of very little, I'm going to say, effort on the data subject's part. There are on the internet loads of sort of standard form letters listing the sort of information you can ask in a DSAR, which you can then send to a company. To give you an example, I've used one recently where about a year ago I was pursued for a private parking fine. It's gone quiet for 9 months, so I've sent a DSAR request off to the company to see whether they're still holding my data, to see whether they're still likely to pursue me for this money that they think I owe them. The company is required to respond within 1 calendar month, which is really quite a short time period to pull all the data together. And it's important to recognise that the GDPR sets out the information that the DSAR is entitled to, and that can include what personal data is being processed, the purposes for which the personal data is being used, and key, who has the personal data and to whom it was disclosed to. And that matters because if we're asking for documents during the claims process that might be caught within the GDPR, Data Protection Act, etc., and they are then disclosed by our insured, there is no reason why the data subject can't then ask for that information and confirm that we've got them, etc. Right, recent case law. The first case, 2 cases of note. The first one is really quite important, actually. The case of Lloyd v Google LLC, 2019, was heard last year, Court of Appeal. I'm sure many of you have an iPhone or an Apple Mac, and on that, their web browser is referred to as Safari. Now, on the iPhone, Google had an app which embedded itself into Safari, and they had a workaround whereby when you were using Safari, it could record information and allow them to display particular adverts. It's something that I noticed was happening if you happen to be in a geographical area. For some inexplicable reason, Google would show you where a local restaurant was or whatever, and you wondered how they knew. Well, it's to do with this little workaround and fudge. Google could then, from this workaround, find the date and time users spent on particular websites, and they could also, as I say, analyze the adverts that they should send them, and they were able to collect data, including geographical data, which you consider to be without doubt, personal. The case went to the Court of Appeal because Google argued that because the individual users of the iPhone, etc., would not really suffer any personal loss, in other words, they were accessing data that wouldn't impact on them in any way financially, then no damages were going to be payable. But the Court of Appeal held that damages would be payable, particularly under Section 13 of the Data Protection Act 1998, on the basis that the Act didn't require that there was damage. The damages were payable simply due to a breach. The Court of Appeal recognised that that personal data had value. It was a commodity. In other words, people would not have consented to disclosing it or giving it freely to Google, but they might have done if they were paid. In other words, it had value. And that is a key issue. The second case, ST v L Primary School, decided this year. A school issued a letter in which the personal information regarding the claimant's behaviour was discussed with specific reference to her Down syndrome. And that letter was sent out to other families who were at the school, and it discussed aspects about the child's behaviour and how they may impact on other families. In other words, the school was almost having an open discussion about the best way of dealing with the claimant's Downs within the school environment. The court held that the letter amounted to a misuse of personal data, and damages of £1,500 and £3,000 were paid to the claimant and the claimant's mother, respectively. Now, it would be wrong to suggest that every claim that falls within a Lloyd type environment is going to result in damages similar to the ST claim. It's not. In Lloyd, the damages will be nominal. You know, it may only be a penny or 10 pence for each breach. But the key thing is to get a balance between those 2 points. If, for example, you had a data breach that resulted in 5,000 people having their information sent to 5,000 other people, then it would only need sort of a penny to be awarded in respect of each incorrect in disclosure for a claim's value to reach £250,000. So it has the potential, particularly given that the fixed cost regimes don't apply to these GDPR cases, for solicitors to lock onto these class actions and see ways of recovering damages. And then it has the potential in particular isolated cases for the breach to be quite severe and for solicitors to incur significant costs and recover some damages in relation to claims by individuals. So from a claims perspective, when we're dealing with liability claims and we're dealing with the documents and data that we collect, we have a couple of principal exceptions to the GDPR applying, and it's probably for these reasons that the GDPR from a liability claims perspective isn't given perhaps the interest it deserves. The first is that the GDPR does not apply where information is required to be disclosed by law, etc., or in connection with legal proceedings, as in Schedule 2 and Schedule 11 of the Data Protection Act. The second is that where processing is necessary for the establishment, exercise, or defence of legal claims, or whoever the courts are acting, or whenever, sorry, the courts are acting in their judicial capacity, that's within the GDPR. Now, I'm cross-referring areas of Data Protection Act and GDPR. The two fundamentally the same, though it's a case of identifying the schedules and the relevant sections within each. But the key thing is to recognise that it doesn't really matter because both are enforceable within the UK. There's a key issue there to look at with regard to litigation privilege. Fundamentally, what those two provisions are saying is that where a case is litigated or likely to be litigated, then the GDPR does not apply. So if we're dealing with an individual case where insurers instruct adjusters or they instruct another party or whatever, we know we've got a case, we've got litigation privilege relating to the documents applying solely to that case. And in those cases, we should be okay. There shouldn't be any suggestion of potentially holding on to paperwork that falls within the GDPR. Though we've got to be careful, obviously, if we're investigating a claim before it's made, or we're investigating a potential claim, I should say. So where does that take us? The first is that those two provisions means that generally the civil procedure rules will trump the GDPR. So if we have a court order requiring or refusing disclosure of documentation, that will override the GDPR specific obligations. And that was confirmed in Dunn v. Durham County Council, a 2012 Court of Appeal case. It basically means you've got a court order, the court is ordering you to disclose or not disclose certain documents. There's a legal reason why you have to disclose them, you must disclose them. The second aspect, however, is a request for data by the data subject cannot be refused if no claim has been submitted, even if it may be seen as a fishing trip. So, for example, if we have what we think is a potential for a claim, and at the same time the claimant makes a GDPR DSAR and requests data from the insured, generally the insured will need to comply. We can't just say, oh, there's a possibility of a claim and not send the information. There's a case of Dear v. Oxford University 2017, which confirmed that. The second case referred to there is quite an interesting case. Hussain was a case where he was pursuing the Medical Defence Union for an indemnity under his policy, and he requested various documents be disclosed, and he went through the normal civil procedure rules. In the end, the court decided that he wasn't allowed disclosure of those documents, and the issue was over recovery of the Medical Defence Union's costs, which were about £32,000. The court commented, and it had an impact on the costs that they awarded, that actually Hussain could simply have asked the Medical Defence Union for a DSAR disclosure request, and that would have taken place for free without any need for making applications for pre-action disclosure. So it's a balance there of saying, in some cases, we might actually want a DSAR to go ahead, or we might just say, oh, that's not a problem, just let them send the information. As long as we know what's been sent as part of the DSAR request, then that ticks the disclosure box for us. So to just summarise those then in terms of the practical effects, if a claim has not been submitted and the claimants make a DSAR request against the insured must decide how to respond to that DSAR request. Insurers can simply leave it for the insured to make a decision. If a claim has been submitted and the claimant makes a DSAR request, the insured must decide how to respond, but we would provide advice on the application of the exemptions above. And in many cases, we would refer to Dunn v Durham and the Court of Appeal decision and say, well, claim's been issued, it's a CPR matter now, it should go through normal processes of pre-action disclosure, allow that to be followed. If disclosure via a DSAR is requested in claims correspondence, i.e. the Data Protection GDPR Data Protection Act is referred directly to insurers, it can be ignored because DSARs can only be made against the company who actually hold on to the information. Certainly we are in a situation where we're dealing with the CPR, we're not required to consider GDPR or the Data Protection Act. If the claimant makes a DSAR request against another party to obtain information particular to the claim, then that has nothing to do with us and we just need to let it run its course. And we can't access that information at all. It's not something that then becomes freely available through disclosure because it's just a DSAR request from the person holding the company holding the information to the claimant. The claimant might do that simply to obtain their own information or their own background documentation, etc. Now, disclosure of third-party data. This is one of the areas where, from an adjuster over the last 3, 4, 5 years, there's been the GDPR Data Protection Act is having some effect. It's starting to change the way we are able to complete our investigations. And it's starting to change the amount and level of documentation that we can obtain and collect. In some cases, we're just not able to collect some documentation because the insured is concerned about the GDPR implications. Third-party data might exist in a number of different forms. It's likely to exist primarily in EL claims, but there are other areas where it becomes relevant. For example, we might have personalised incident reports relating to product failures. So the incident report is attached to a particular individual, and then all of the product failure detail and documentation is attached to that. We might be asked to disclose previous accident reports in respect of incidents, etc. For example, RIDDOR requires that certain personal information is kept as a matter of law. The reporting regulations stipulate what needs to be completed both on your accident report form and also within the F2508 environment. It doesn't follow, however, that legal obligation to obtain the information and to record it means it has to be disclosed to third parties. And certainly previous accident reports is very much personal data. It might have comments about health in it and to do with the way the accident is reported. And as a consequence, we've got to be very careful where it's sent to. The disclosure of witness statements, including names, addresses, and other personal information about the witness or another party. In an employer's case, it might be relatively straightforward that someone's just seen an incident and we possibly could redact out the name or address or other personal information to make the statement anonymous. But in other types of cases, so for example, stress and abuse cases where personal information is more prevalent, it will create problems. In stress and abuse cases, we may have cases where the information about the perpetrator is required, and that obviously will be personal, is likely to include employment or health or other information which would bring it within special categories of the Data Protection Act. What we're starting to see is that data will be redacted, certain information will be removed, or the documentation will be redacted. Certain information will be removed from the paperwork that we're seeing. A common example is IP for injured party within an accident report, which doesn't identify the individual in any way. The individual can't be fundamentally identified, or there's nothing within it that means that that then becomes data particular to the person concerned. Also, we may find that data is being redacted to turn other personal data into generic data. The police or other public bodies will often do this with an incident report or with their own witness statements. They will start removing elements of it so that people cannot be identified. And there is a question there about whether we're then ticking the disclosure box. That is, if we get something in from the police and disclose a police report, or we get something in from another body and disclose that report, we can argue that that is disclosure because we're only disclosing what we've already got. But are we complying with a disclosure obligation if we take documents from our own insured, the insured has redacted them to remove personal data, and then we then disclose them? It's a difficult fine line. A few years ago, I was dealing with a large insured and encountering a number of claims on a regular basis. So I drew up a consent form which requested HR, occupational health, wages, training records, etc. And I put it together in a nice box format with sections for signing, etc., etc. But the insured wouldn't work with that because from their perspective, from a Data Protection Act perspective, they wanted individual documents for individual departments to confirm that the person involved had given consent for the disclosure of that particular set of information. And that, particularly looking at the need for explicit consent, is understandable. We may have our standards of what we think should be disclosed, but ultimately it's the insured who have the GDPR, Data Protection Act obligations and need to comply with it. And so we're often finding that they have their own rules about what we can and cannot have, and they have to go through due process to make sure that whatever is released to us is appropriate and complies with their obligations. So if we're in a situation where we've got some documentation, we think it needs disclosed, but we're not too sure, or the insured are not too sure about whether it can be disclosed or not, often what we would find is that the claimant solicitors will either accept that level of disclosure or accept what we're willing to provide, or alternatively they're going to challenge it. And the way they would challenge it is by issuing a pre-action application for disclosure, particularly if it's third-party data. They can't get it by any other means. The case of RE-A 2004 is, I suppose in the GDPR sense of things, it's quite an old case, but actually it's very helpful, mainly because it's a High Court case. The claimant was after information about about a child, and they went to get an order for pre-action disclosure, and it went through a long and lengthy court process because the data that they were asking, or the information they were asking to be disclosed, also included very sensitive information about the claimant's mother's medical condition, and the local authority concerned did not feel comfortable about disclosing it. And in the end, the matter went to the High Court, who ordered disclosure of the documentation. Now, that makes good logical sense with what we know. We know that that court order will trump GDPR, Data Protection Act, and that's the end of the matter. But key was that the court ordered both sides to pay their own costs. In other words, the contentious issue of disclosure was enough that the court did not feel that it was a straightforward pre-action application request, which the claimants refused, therefore they were entitled to costs. Hussein and Medical Defence Union, which I've referred to earlier, is a case where the DSAR helps in those situations. It's not disclosure of third-party information, it's disclosure of information that could be obtained through a DSAR, in which case let the DSAR run its course and allow for the information to be disclosed. Okay. So lots of bits of information there, but to sort of summarise, and summarise really where we are, I suppose, the Data Protection Act 2018, or GDPR, imposes obligations for the processing and retention of personal data. A breach may result in a separate claim, albeit defences apply if it is a civil claim governed by CPR, which will be the majority of the liability claims that we are dealing with. Having said that, great care must be taken in the disclosure of personal information identifiable to a third party who is not a party to the proceedings. The case of Lloyd shows that if third-party data is disclosed, if we don't have a good, solid legal reason for disclosing it, we may well end up with the insured being in breach of GDPR or the Data Protection Act. And that's a key thing, and insureds are recognising that. They are very careful about disclosing that sort of information. And we need to be wary and careful. If anything, we should lean towards non-disclosure of the data. If we're concerned about third-party data being disclosed and it's not right to disclose it, we can refuse that. If possible, we might be able to get around any refusal to disclose by redacting the data, and that's something the insured will need to do. They've got the Data Protection Act, GDPR obligations. If they can redact it and we can take that redacted data and information and send it on, then that might tick the disclosure box. But the last point is, don't worry about pre-action applications. If the claimant wants to make a pre-action application for disclosure of third-party data or any other data that we think might be GDPR sensitive that the insured don't want to release, then that's probably not a bad thing, because it means we then have a clear court authority to undertake that disclosure. It's questionable, if we think the matter is straightforward, whether we would ever defend the pre-action application for disclosure. You might simply let it run through and end up with the court order that we want to tick our own box. The case of Sharp and Leeds City Council 3 years ago reduced it basically meant the pre-action applications within the portal framework operate within the fixed cost regime. That's tended to reduce the number of pads being made because solicitors can't make money out of them. The payment of £300 for the pad application doesn't really cover the labour involved and the time involved. Obviously, there's cost of defending it, and we also have to make a decision with GDPR whether we want to incur the cost of defending when that information might be quite sensitive to the insured. But overall, it's better to be safe than disclose something and worry that we might end up with a Lloyd type liability attaching for the disclosure of something that we shouldn't have disclosed. Okay, that's as much as I wanted to say, but I do want to just touch on a couple of cases very quickly. The first is the case this year that's received a lot of publicity of Morrison's v various claimants. It's a GDPR case because the employee of Morrison's disclosed personal data, but he did that in connection with his employment. And so the Supreme Court has looked at it from a vicarious liability perspective. In the case of Morrison, the employee acted maliciously. He'd ceased working for them and he was on a bit of a vendetta, but it still resulted, the disclosure took place whilst he was working for them, and then he effectively left. But the case is primarily concerned with vicarious liability, but a lot of GDPR issues do evolve around that, and data being leaked and sent out. And so that issue of vicarious liability in the data environment was important. The second case is recent. I'm just going to look on my notes. 26th of June 2020, Melanie Stanley and Tower Hamlets. Basically, it was to do with proceedings being issued against Tower Hamlets, and the proceedings were sitting on their doorstep because they were issued just as COVID-19 was coming into effect and the Tower Hamlets offices were all being vacated. The claimants argued that there should be some procedural penalties, and the court declined to do so, calling COVID-19 exceptional times that could warrant procedural delays. There's been another case last month, 23rd of July, called Hotel Portfolio UK Limited, another High Court decision concerned with an extension of time for disclosure of witness statements, and the court has allowed an extension, even though really there was probably no reason for them to have done so. But again, COVID-19 being the primary issue. I'm referring to those two cases because from an adjusting perspective, we are finding that solicitors generally are allowing us an extension of time. We're being allowed to investigate. I expect they'll start getting a bit harsher. Now things are more relaxed, and we're effectively back doing site visits. But clearly in some cases, insureds have got local lockdowns applying, or there are restrictions in access to their premises. In some cases, staff are still furloughed and offices are still closed. But generally, as long as we've got good reason, both in terms of saying it's a COVID-19 claim, but ideally saying that it's something quite specific, i.e. that site is closed or that person's unavailable, claimant solicitor is not pushing back, and I think the courts fundamentally would be incredibly critical if proceedings are issued. So hopefully that makes sense. Hopefully that's a bit useful in terms of some of the situations you're encountering as well. Thank you. That summarises what I would like to say. We have a bit of time. If anybody would like to make any questions, then or put any questions to me, then please do so.
You do have a couple of questions there, Adrian. Can you see them in the
Just
pane, or I can read them out?
Okay, just looking at the questions. How would I define the insurer's role in the data processing cycle, controller, processor, or joint controller? Part of that comes down to the nature of the data. I mean, they are data controllers of data held within the insurance environment. But in terms of the claims process, the primary control that we're going to be interested in is the insured and the insured's release of data to us. Once it gets to us, it becomes the insured who's holding onto the data. So they become the controller for that purposes. Certainly from an adjusting perspective, we are acting as a third party for the insurer as a controller. The phrase joint controller is quite interesting, but it's controllers at the separate process. But I suppose I'm going to sort of sidestep the question to a certain degree. From an adjuster's perspective, my interest is in the insured as the controller. In other words, does the insured feel happy supplying us with the data? And the main reason I'm saying that is that because once we get it, we're doing it within that litigation privilege environment. So as an adjuster and as a liability insurer, we are effectively controlling the data, but we are falling within that exemption because we're using the litigation privilege that we've got attaching to our particular files. I hope that's helpful. I'm just trying to. I'm sorry, that's the only one I can see, Hayley, I'm afraid.
Oh, you answered the one, how would you define the insurer's role?
Yeah.
So the other one is, if a third party manages to access an account and take action on it under your identity and you suffer harm, can you use SAR to access that data on your account, even though it was not you who contacted the company, although to all intents and purposes that data was recorded and processed against you?
Goodness, that's a to be honest with you, I've not come across that. I mean, I would think, try and answer it two ways. If you set up an account and you have done that legitimately yourself, and then someone uses that account, and then it's found out that they've spoofed your identity and gone into the account, I've seen no reason why you couldn't make a DSAR request in that situation. I would have, and I would probably want to get solicitors' advice on it. If they've used your identity to set up an account, I would have reservations about making a DSAR request at that stage. And the reason I'm saying that is that they would have used your identity, but they would not be you. So in that regard, would you have access to data that isn't your data? Because you wouldn't necessarily know whether they've used your data or they've not used your data, nor would you necessarily know or want to accept that that data then becomes your responsibility. I think if you made an application, a DSAR, I think it would be declined on the basis that you wouldn't be the person about whose data you're requesting, even though you would. I hope that sort of makes sense. Within a claims environment, I expect some of our cyber guys who deal with the claims might have come across that before, but I haven't from a third-party liability perspective. I hope that answers that one. Is it just the 2 questions, Hayley?
Yeah, just those 2 for now.
Okay. Okay then. Thank you very much, everybody.